The reenactments and commentary in this program may contain frank talk of a sexual nature. Viewer discretion is advised.
Robert Blake not guilty, Scott Peterson to die, and Michael Jackson, well, probably a little too soon to call that one. Nonetheless, a big day for courtroom drama for high-profile cases and certainly for some high-priced lawyers. I'm James Curtis, and this is a special one-hour edition of our exclusive coverage of the Michael Jackson trial right here on E! To give you a better context for the new testimony from detectives that you'll hear in just a few moments, we want to begin by re-examining some of the testimony of Jackson's accuser. First up, DA Tom Sneddon questions a teenager about a night at Neverland. Here's what the jury heard, and you heard if you've been listening over the last couple of weeks, according to courtroom transcripts.
They couldn't hear what you had to say, Gavin. I know it's hard. Just lean right into it.
He told me that males have to masturbate.
All right. Now, when he said that, what, if anything, did he do or say after that?
He said that if I masturbated, and I told him that I didn't, and then he said if I didn't know how, that he would do it for me.
And what did you say?
And I said I didn't really want to.
All right. And then what happened?
And then he said it was okay, that it was natural, and that it's natural for boys to do it.
All right. What happened after that?
And then so we were under the covers, and I had his pajamas on because he had this big thing of pajamas, and he gave me his pajamas.
Okay.
And so I was under his covers, and then that's when he put his hand in my pants, and then he started masturbating me.
Could you see Mr. Jackson while he was doing that to you?
Not really. I wasn't really looking at him.
Could you tell whether or not he was moving?
Well, he was himself?
Yes.
I wasn't really looking at him. I could kind of feel him moving, but I mean, I never really saw him moving.
Do you know approximately how long Mr. Jackson masturbated you?
Maybe 5 minutes, I guess.
Do you know what an ejaculation is?
Yes.
And did you have an ejaculation?
Yes.
Did Mr. Jackson say anything to you afterwards?
I kind of felt weird. I was embarrassed about it. And then he said it was okay, that it was natural.
Did anything else happen that evening between you and Mr. Jackson?
No, after that, he tried to say that it was okay, and that kind of like to comfort me because I felt weird. I felt weird about it. And then after a while, we just went to sleep.
Next, the prosecutor targets the alleged second incident of molestation. Now, a programming note, the actor hired to play Gavin bears no resemblance to the actual accuser.
Was there any other occasion where Mr. Jackson touched you?
Yeah.
When was that?
Well, there was about a day after that he did it. He did it one more time.
All right. Where were you?
In his bed.
And was it daytime or nighttime?
It was nighttime.
And who else was there anybody else present besides you and Mr. Jackson?
No.
And what were you doing up in his bedroom at this point in time?
Well, we just came back from the arcade again, and then we went up to his room, and then we were sitting, I think we were watching TV or something, and then we were on top of his covers, and he did it again.
How were you dressed on this occasion?
In his pajamas again, because I would always use his pajamas.
All right. And how was Mr. Jackson dressed? Do you remember?
He was in his pajamas too.
Now tell us what happened.
The same thing happened again, and he said that he wanted to teach me, and then we were laying there, and then he started doing it to me, and then he kind of grabbed my hand in a way to try to do it to him, and I pulled my hand away because I didn't want to do it.
Did Mr. Jackson say anything before he reached over and grabbed your private parts?
He would always say that it was natural and don't be scared, and it was okay.
Now, how long do you think it lasted the second time?
The same time.
Did you ejaculate the second time?
I think I did.
Now, when was it, at point in time, that Mr. Jackson reached over and grabbed your arm?
Maybe like halfway through it.
Did you say anything to him when you pulled your hand away?
I said that I didn't want to.
Did Mr. Jackson say anything to you?
I don't think he did.
Were there any other occasions where Mr. Jackson tried to do something to you that you felt was inappropriate that you remember?
No.
In light of this testimony and in light of the big verdict for Robert Blake, the issue of credibility is all over the place, Ricky.
It's critical. And one of the reasons that the testimony of the accusers in the Blake trial is exactly like the testimony of the accuser, his siblings, in this trial, is that there's testimony that can be inconsistent.
Yeah.
And it's a question of, do we believe these people or not? A juror this morning on the radio on the way to work said that the credibility of the accusers in the Blake case was absolutely nothing. Yeah. What if a juror here feels the same way?
There's a lot of parallels. All roads seem to lead to Robert Blake in that case.
Yeah.
All roads seem to lead to Michael Jackson here. But it becomes a credibility issue. And jurors, as we saw in the Blake case, don't like liars, and they tend to believe them less. And you have 3 young kids here who have either admitted or one could certainly infer their lying.
But
secondly,
Go ahead.
jurors don't like police that act like Keystone Cops.
And we're going to talk about the police rushing to judgment, Sean, in just a moment.
Thank you.
But what about the idea that, unlike the Blake case, here you have kids, and you have a very different sort of charge? Doesn't that change the dynamic?
I don't think so. As we all know, the prosecution has the sole burden of proof in a criminal case, and it all rests on their evidence. If the witnesses are not credible, if there are a number of inconsistencies, then that should read, according to the law, to a not guilty verdict.
It should. But if these jurors get emotionally invested, I'll let you make that point when we get back, Ricky, will it change that basic dynamic of credibility of these witnesses? Defense attorney Tom Mesereau immediately launched into an all-out attack on that very same issue, the credibility of the young accuser.
And what you're saying is that after your interview with the social workers, where you were asked questions about Michael Jackson, you're saying it was after that inappropriate touching began, correct?
Yes.
While Mr. Jackson is being investigated by Los Angeles County, true?
It didn't happen until the last few weeks before I left, or 2 weeks, somewhere around there.
Well, let me ask the question again.
Okay.
The 3 social workers were from Los Angeles County, true?
I think they were.
And they were asking you questions about whether Mr. Jackson had ever inappropriately touched you, correct?
Yes.
And you said no, right?
Yes.
You knew they were investigating Mr. Jackson, right?
No. I thought they were just going to try to ask me, and that was it. I didn't know.
But what you're telling the jury is that after this investigation starts, and after you and your family are questioned, Mr. Jackson supposedly starts touching you inappropriately, right?
Yes.
Until you realized you were not going to be part of Michael Jackson's family, you never made any allegation of child molestation, correct?
I didn't want to be part of his family. I just saw him as a father figure.
Until you realized Michael Jackson was not going to meet you in Brazil, you never made any allegation of child molestation, right?
I didn't even really want to go to Brazil.
Until you left Neverland for the last time, you never made any allegation of child molestation, correct?
I didn't tell anyone until I left for the last time, correct?
And never called the police until after you'd seen 2 lawyers, right?
Object as argumentative, Your Honor.
Overruled.
Yes. It wasn't until I saw 2 lawyers, until I told the police what really happened.
Okay. Now, you're aware, are you not, that you have until the age of 18 to file a lawsuit against Mr. Jackson if you choose to, correct?
No.
You've never discussed that with your mother?
No.
Never discussed that with Larry Feldman, the attorney?
No.
And never discussed it with Bill Dickerman, the attorney?
No.
Okay, you're also aware that if Mr. Jackson is convicted, you could automatically win that civil suit, right?
No.
No one's ever discussed that with you?
No. We said things like, oh, we don't want his money and stuff like that.
Never discussed that issue with any attorney, right?
No.
First time you've heard about it.
About that I can... You just told me now that I can sue him till I'm 18 or something like that. I didn't even know about that stuff.
Didn't even know about that, right? And never heard your mother mention it?
No.
Howard Weitzman, this is inherently incredible on a certain level, isn't it? To the extent that, why do you take a kid to see a lawyer if he hasn't told anybody about some problem, and the problem all of a sudden comes up when you're talking to a lawyer? Am I just missing something?
No, it's just not believable testimony, particularly when the lawyer here is the lawyer that represented a young man 12 years ago
Just happens
against
to be
Mr. Jackson.
the same lawyer.
Yeah, it just didn't happen to be. There's two very important facts that we need to focus on. The first time investigators and social workers and Santa Barbara sheriffs investigated this case, it was before the meeting with Feldman, and they chose not to go forward. Then the meeting with Feldman, and then suddenly they decided to go forward again. That in and of itself is very suspicious.
Sean, with respect to that very idea and sort of taking it the next step forward, I said a minute ago when we revisited this testimony that the jurors don't get to watch it again, but they can call for a readback. No doubt they're going to be doing the same kind of analysis that we're talking about. Wait, how does this all line up?
Yeah, I don't think it makes sense at all. I don't think it is at all credible that he's saying that he's never even heard talk about he can file a lawsuit till he's 18. That just strikes me as absolutely unbelievable. That no one has said that to him until just now.
Let me take it from the other side, though. We're looking at the case, I think, as Tom Mesereau would present it, it's the mother who is the lead grifter here.
Yes.
So his mother is the person that's put everything in motion. And the kids just kind of follow like three ducks in a row. So the fact that he himself may not know that he has till the age of 18, that may be okay.
I still don't believe it.
But I think Mom knows.
Yeah,
that
Mom
he has
knows.
till 18.
And does thou protest much with respect to making another statement that seems to be contradictory? Oh, we don't want the money and stuff like that. Isn't that the same thing as discussing it? Up next, a detective defends the search at Neverland, and later, the latest from one of our favorite comedians, Jay Leno, at least for this trial purpose. Plus, shades of O.J. Sean, allegations of evidence contamination. We'll be right back.
The reenactments and commentary in this program may contain frank talk of a sexual nature. Viewer discretion is advised.
Welcome back. Now that we've revisited with you testimony from the accuser, we move on now to the new testimony that came in. It's from a detective with the Santa Barbara Sheriff's Department. The defense claims that when the police raided the Neverland Ranch, it was simply a rush to judgment. And DA Tom Sneddon, though, of course, presents a different motive for that very same search. Here's how Sergeant Steve Robel responded to the questions according to the courtroom transcripts.
Now, Mr. Sanger asked you a lot of questions about what you did from after you interviewed the family on a couple of occasions until the point that you executed the search warrant on November 18th. Do you recall those questions?
Yes, I do.
Now, was there a decision made with regard to how those search warrants were going to be executed?
Yes, there was.
Was there a strategy involved in that?
Yes, there was.
And what was that?
After interviewing...
I'm going to object. This calls for hearsay, and it does not appear to be relevant, and it's beyond the scope of cross.
Doesn't it? Isn't that exactly what you were going into yesterday?
Absolutely.
Overruled.
Go ahead and tell the ladies and gentlemen of the jury.
After conducting the interviews with the family, myself, along with the other investigators, including the DA's office, met and we conferred, and we decided at that point, like we do in several investigations sometimes, we'll go in and advance further and interview people to gather more information prior to serving a search warrant. In this case, we chose not to, due to the nature of the investigation and the high-profile case being involved with Michael Jackson. So what we decided to do is drop a search warrant and serve it. And we did it that way because if we were to go out and contact people prior to that, we were concerned about evidence that we were looking for that would corroborate the statements of the children would be destroyed or would not be there. And it would compromise our investigation. So that's the reason why we chose to serve the search warrant.
But it doesn't explain why you did the arrest that same day. Next, did the search warrant uncover items previously mentioned in testimony? And a clash over, how do you define smut?
Now, Detective Robel, at the time that you executed the search warrant on November 18th of 2003, okay, did you, during the course of the execution of that search warrant, you personally observe items or things that you felt corroborated the statements of the children?
Objection, Your Honor.
Sustained.
On the date that you executed the search warrant, did you see the mannequin?
Yes.
Did you see the briefcase with the pornography?
Yes.
Object.
Yes, objection. Violates the court's rule.
You didn't say adult material.
Oh, God, I'm sorry, Your Honor.
All right. Just to rephrase your question. Sustained.
Well, you think like a lawyer. I really apologize. I apologize to everybody.
Go ahead.
Okay. Did you see the briefcase with the adult material in it?
Yes, I did.
Did you go to the arcade?
Yes.
Did you see the jukebox?
Yes.
Did you go in the cellar?
Yes.
Did you see the wine?
Yes.
Shadows of Pamela Mackey in the Kobe Bryant case.
Exactly.
She was the defense attorney for Kobe Bryant. She just happened to keep mentioning over and over, contrary to the court's order, the name of the accuser in open court.
Okay.
Now the shoe's on the other foot. Snedden says doesn't say adult material. He uses the word pornography. Obviously, there was a court order here saying don't use the word pornography, probably because it's too prejudicial, but it comes out anyway.
All right, I'm going to defend Mr. Snedden. He could have easily slipped. He could have really meant to say adult material. It's a contrived word. We're used to saying in the business pornography, and he apologizes. Now, is it a bad thing that he did? Yes, it's a bad thing, but hey, I'll bet you the jurors use the word pornography when they're looking at the material.
Is it really pornography, though? I mean, some of the titles of the magazines that we've heard, I wouldn't characterize as pornography. I think pornography has, you know, a taint to it. It sounds bad. And I think that Mr. Snedden used that word very purposefully.
Let's change gears for just a second, Howard, related to this idea in the previous testimony that we heard. The search warrant closely followed by, I believe it was either the same day or the day after, the service of the arrest warrant. Obviously, they hadn't had time to analyze the tons of information that they took from the Neverland Ranch.
This was a publicity stunt,
and on the same day of his release, by the way, of his number ones.
They just happened to have all the cameras and press there. They just happened to have a press conference all set up. It was staged, in my opinion, much the way Mr. Snedden staged using the word pornography instead of adult.
Well, I got to go with Ricky on this. I got to go with Ricky.
You got to execute the search warrant before it's going to disappear.
Yes, we'll continue this, obviously. We even talked during the breaks.
No, we don't.
Now, the witness takes us back to a very pivotal moment in his investigation.
You've told the jury one of the officers who interviewed Gavin in the initial interview and in the follow-up interview, correct?
That is correct.
And during the initial interview, Gavin disclosed to you certain things that Mr. Jackson did to him, correct?
That is correct.
Now, can you describe to the ladies and gentlemen of the jury what Gavin's attitude or demeanor was at the time that you got into that part of the conversation?
Prior to getting into that area, we were just discussing just his stay at the ranch. He appeared to be, fine with talking to us, open, very positive. As I got into questioning him regarding the actual molestation acts and having him share with that openly, immediately I noticed a change in Gavin's demeanor. He basically became very, very quiet, folded his arms, and just sunk down into his chair. And it took me approximately 10 minutes or so to reassure him that he was doing the right thing. And he, at one point in time, kind of got a little choked up. And eventually was able to go on ahead and disclose what acts occurred.
I'm going to object and move to strike the last sentence as a conclusion of the witness.
Stricken. The jury's admonished to disregard the last sentence.
The term chomping at the bit doesn't begin to describe Howard Weitzman right about now. Next, 2, 5, 7. Do the numbers add up?
Now, yesterday, Mr. Sanger asked you several questions about statements that Gavin made to you about the number of times that he told you that Mr. Jackson molested him. Do you recall those questions?
Yes.
And do you recall that on a couple of occasions he told you he thought it was between 5 and 7 times?
Yes.
And do you recall in the courtroom here, he indicated that there were at least 2 times that he was very specific about the information in which he was, the defendant molested him? Do you recall that?
Yes.
Do you find any inconsistencies between what he told you and what he said in the courtroom?
Objection, Your Honor. That calls for speculation and comment on a witness's testimony.
Sustained.
Were you present during a conversation where Gavin explained the 5 and 7, the 5 figure that he gave you versus the 2 figure that he testified in court?
Yes.
And what did he say in that regard?
Objection, vague as to time.
It's
Overruled. You may answer.
Go ahead.
During my initial interview with him, he had told me that he was specific about 2 events that he recalled occurring. And he also told me that he believes that it happened between 5 and 7 times. And he could not articulate exactly what occurred, but he believes that it happened more than twice.
No further questions, Your Honor.
I don't know. I just don't. Howard, you should have came back from the commercial because you can't wait. Go ahead.
Well, this interview, I think, is great for the defense unfortunately, for the credibility of the young man. Yes, I realize he's young. Yes, perhaps his memory isn't as good.
Right.
He's talking about masturbation, ejaculation for the first time in his life, and he cannot remember if it's 2, 5, or 7. If I'm a juror and I'm weighing Michael Jackson's guilt or innocence on this young man's testimony, there's reasonable doubt right now.
And even more so, Ricky Kleeman, with respect to what I recall, and I actually went back and looked at this portion of the transcript, I read an emphatic no on the cross-examination of Tom Mesereau. Did he ever touch you, aside from those 2 times, more than twice? No.
Well, you are going to have inconsistencies here, and I think that what Howard says is really where the jury has to go. It's what did he say as close in time to the incident, which is this. It's not the 2. It is the 2, 5, or 7. What does that tell us?
And certainly it still helps, perhaps, to set up what we must expect will be a plaintiff's expert witness to explain it all away. When we return, call Gil Grissom. CSI is under attack. Stay with us.
Arrest warrant for Mr. Jackson has been issued on multiple counts of child molestation. The bail amount on the warrant has been set at $3 million.
The reenactments and commentary in this program may contain frank talk of a sexual nature. Viewer discretion is advised.
Welcome back. With the investigative detective still on the stand, defense attorney Robert Sanger insists that timing is everything. Here's what the jury heard according to the courtroom transcripts. And a programming note, an unindicted co-conspirator named Dieter is mentioned in this testimony.
Okay, so again, search November 18th. And sometime after that, sometime between November 18th and January 19th, you saw a portion of the rebuttal video, correct?
That is correct.
And one of the other officers said, look at this, and he was looking at it on his screen, and you came over and looked at it?
Yeah, it was a DVD or video.
Okay. And then the first time you watched the full tape was January 19th, is that correct?
That's correct.
When you first... Who was it that showed you this tape, by the way?
Detective Bonner.
Okay, so when Detective Bonner showed you this tape, he called you over and said, look at this, right?
Yeah.
And when you first saw it, it was rather remarkable, wasn't it?
Remarkable in what way?
I'm asking you. Let me ask you this, then. It did not appear to you at that time to be consistent with what you had been hearing from this family up until the time you saw it?
When I saw bits and pieces of what he showed me on that day, I was not alarmed by that because of... I recalled what Janet had told me in her initial interview about them being forced to do that by Dieter. So it was not alarming to me at all regarding what I was seeing or the way she was acting, if that's what you're asking.
So forced to say things like, call Michael Jackson daddy and father figure and all that?
Exactly.
Okay, and you weren't... You sat here now, you've seen the cards where that's what this family does. They call people father and mother, and they tell them they love them, and they do all that, right?
According to the cards, yes.
You weren't aware of that at the time, were you?
No, I wasn't.
And now the defense tries to establish a pattern of behavior for the family of the accuser, and this judge says, I'm no Lance Ito, reminding everybody exactly who's in charge.
When did you first learn that this family would send very effusive cards and letters to people calling them mommy or daddy and telling them they're part of their family and that sort of thing?
I'm going to object to the question, as this family is vague. If he has specific people he wants to refer to, I think he should do that.
I'm referring to Janet, Starr, Gavin, and Davelin, whose names already show up on the cards and evidence in this case with regard to Palanker and Michael Jackson.
Just a moment. I don't know how this has deteriorated where both of you are talking freely to the jury about your questions. So let's go back to the...
I'm sorry, Your Honor.
Let's go back to the specific objections and not respond to them. The objection is overruled. You may answer now.
Upon reviewing, after the search warrant, some of the items that were seized, when I was going through some of those items, I ran across some of the cards and so forth that you have displayed here in court.
Now, we want you to know that Janet, you heard mentioned, although her name is actually Janet Jackson, is the mother of the accuser. But with respect to this testimony, how's Robel doing, Sean?
Well, Robel's fine, I guess. I don't understand why Mr. Sanger allowed Robel to explain how the rebuttal video is not a problem as far as the police are concerned. The rebuttal video is very powerful evidence, and I would have allowed the rebuttal video to speak for itself.
Well,
not
let me tell you, having actually sat in the listening room and seen the rebuttal video that they're talking about, it's not the video that we saw on the air that Jackson had produced. I think it was Fox or somebody else who ran it. It is actually the tape still running while they're doing the directions and that kind of thing. It's very, very powerful. I think it's a good idea, frankly.
You think it's a good idea to have law enforcement interpret the tape?
Yeah, it does, because I think it's going to point out a conflict, a very strong conflict, which I think, Howard, is going to be a point that you're going to want to make in about 3 minutes, and that is this whole idea of making this conclusion, making a judgment, and then doing an investigation following that before you know all the facts.
Well, this is one of those classic rusted judgment cases again. The appearance, as I said earlier, all roads seem to lead to Michael Jackson doing bad things, and so it's the classic, you know, aim, shoot.
Well, but come on, Ricky, after all...
I mean, you have to deal with the fact that the police heard from someone who said that he was molested. What are they supposed to do, ignore it?
And indeed, spoken like a true police commissioner's wife, you have to act on credible evidence. As testimony continues, tempers flare as the defense implies we're dealing with a persecution instead of a prosecution.
So, November 18th, you and your department formed the opinion that you had probable cause, you should go out and arrest Mr. Michael Jackson in this case based on what you had then, right?
That is correct.
And then you investigated the case after you got the arrest warrant.
That's incorrect.
You didn't investigate the case after you got the arrest warrant?
We investigated the case prior to the search warrant. We continue to investigate the case, and we are currently continuing to investigate the case as this trial is going on. This is a continuing investigation.
So, a part of the continuing investigation you're just talking about, for instance, is an attempt to discredit witnesses who have come forward to say that the are not telling the truth. Is that correct?
Your Honor, I'm going to object to this as beyond the scope.
I'm not going to sustain the objection. Go ahead.
To discredit? No. It's when we receive reports from you as the defense that we have accusations or things in your reports. We're going to go and see if we can interview them to clarify and to make sure that that is correct. And we're also having other people coming forward besides your witnesses that you've talked to that we're following up leads regarding the case.
As the next witness, Detective Paul Zealous takes the stand, are there echoes of O.J. as the defense asks about handling of the evidence?
So let me ask you, was it your intention that the contents of this briefcase be evaluated and analyzed by the CSI or forensic unit at the Sheriff's Department?
No.
Did you think anything about that?
No.
You were wearing gloves when you seized this item, correct?
Correct.
And you put it in a plastic bag, correct?
Correct.
You didn't think forensics was ever going to look at this?
Well, I'm sure they would.
Okay, and you're sure they would for what purpose? Look at that for fingerprints, perhaps?
Perhaps.
Okay. Do you think that would be pretty much a priority?
Possibly.
Possibly. And in 2004, March and April of 2004, in that time period, this briefcase was brought to the grand jury in Santa Barbara. Is that correct?
Correct.
And it was your understanding it had been to forensics, right, when you brought it in?
That I'm not sure of.
You're not sure. By the end of the grand jury proceeding, you came to realize that nobody had checked for fingerprints on these materials inside of Sheriff's Item 317. Isn't that correct, sir?
Yes.
That was kind of a shocker, wasn't it? It wasn't a shocker?
No, not to me.
You're kind of smiling. This, in fact, when that was learned, that's when you were sent in with gloves for the grand jury to look at the materials, so they wouldn't be picking it up and handling it. Is that right?
Correct.
However, during the course of that grand jury, the contents of this briefcase, Sheriff's Item 317, was handed to Gavin so he could look through it, see if he could identify it. Isn't that correct?
Objection. No personal knowledge, no foundation.
I think he's asking him if that happened, so I will overrule the objection.
I would not know.
So you weren't advised by the end of the grand jury proceedings that Gavin had taken the contents of this and looked through it at the request of the district attorney?
Same objection.
No.
All right, Howard Weitzman, let's go back just a moment. Where is the training that you keep talking about? We've heard cross-examination from the previous witness, and I suspect it will continue with this witness about essentially that rush to judgment theme. Okay, let me get this straight, says defense attorney. You made the arrest, you served the warrant, then you continued your investigation. That's good stuff.
Yes, and it's appropriate. It's appropriate. I'm not saying it's not. However, it's what they've done, how they've done it. The perfect example is the search warrant being executed, an arrangement for Michael Jackson to turn himself in. He flies in from Las Vegas. They meet him at the airport after he flies in with a private plane and then take him into custody there. If they're going to allow him to surrender, they should have allowed the plane to land, let him get into a car, and drive to the
wait, that's
headquarters.
not fair. That's not fair. Ricky Cleveland, wait.
There's a point I want to make, James.
Go ahead.
The point is, it was set up to have a certain look to the public.
Hey, I disagree. Ricky Kleeman, with respect to that surrender, one, this is a press-laden, intensive incident. The cameras are everywhere waiting for him to land. They had to provide the circumstances of security to allow that plane to pull in that hangar nose first. It may have looked like a publicity stunt, but had they not done that, the media would have been everywhere all over this Jackson camp.
It is called security. It is called order. This was the best way to do it, to assure that he would be at the courthouse, that he would be booked appropriately.
Sure.
The police really did, or the sheriff's department did, try to follow a protocol.
I think they did, and certainly that plays out. We'll discuss it.
I definitely don't agree.
He does not agree. I'm so surprised. Still ahead, what Jay Leno said and an investigation of the investigation. Stay with us.
The reenactments and commentary in this program may contain frank talk of a sexual nature. Viewer discretion is advised.
Welcome back. Detective Paul Zealous faces more hard questioning from defense attorney Robert Sanger. Here's what the jury heard according to the courtroom transcripts.
As an investigator, when you're interviewing a witness, you're supposed to get information. You're not supposed to convey to the witness what you would like them to say, correct?
Yes.
Do you recall now, having refreshed your recollection, that Mr. Snedden said, so, in your mind, one of the things that you're thinking is, they're doing this video that they want you guys to do, that if you ever told them the truth about being molested by him, that nobody would believe you. Remember that question?
Yes.
And then Gavin says, yeah, that they would use that and say that we're lying. That's what I think they used it for. I think that's why they told us to say all those things in the tape. They told us it was for so they could release the tape out to the media for rebuttal for what they were all saying, but I don't think they were like kind of forcing us to say those things. 99.9% of the things that they were telling us to say weren't even true. So, and then the answer ends. Was that what Mr. Snedden said and what Gavin said in response?
Yes.
And at that point in the interview, as the investigator in the case, it was your understanding that what Gavin was saying at that point is that he was claiming he was molested before the rebuttal, and that this was the rebuttal was to cover up a molest. Is that correct?
No.
Well, that's what Mr. Snedden was asking, wasn't it? If you ever told the truth about being molested by him, that nobody would believe you?
Yeah, Your Honor, that calls for a conclusion on the part of the witness. It's
sustained.
All right, I got to help this out. I can do that in just a minute, though. Next, the ever-elusive timeline.
And then, immediately following that, Mr. Snedden says, so, in your mind, one of the things you're thinking is they've done this video that they want you guys to do so that if you ever told them the truth about being molested by him, that nobody would believe you, correct?
Correct.
And then Gavin essentially adopts Mr. Snedden's interpretation.
It was... That question asked by Mr. Snedden was a clarification of an idea that was given to us by Gavin prior to that.
So that he was molested before the video, and the video was done in order to negate any claim that he was molested?
No.
And you understand that other times, Gavin has claimed that the molest occurred at the end of his stay at Neverland, not in early February or mid-February, correct?
Are you asking my understanding? I'm sorry, could you repeat the question?
Well, let me clarify it if I may. Other times, you told us July 7th. He said it was right at the end of his stay. That would have been March, correct?
Correct.
Sean Chapman, Holly, let's talk about this attorney for just a moment, taking off on a point that Ricky made yesterday. This is another attorney, not the lead attorney, not the main guy, Tom Mesereau, who I think everybody agrees is phenomenal. I read this transcript yesterday, and here's a small example of it. A little bit of fumbling, a little lack of clarity on the part of this attorney. What does that do to this trial?
Well, I agree with you. I think it was very confusing, very hard to follow. But what I think he's getting at is this, and as you know, I was on the O.J. Simpson defense team and think that Mr. Simpson is innocent. But some people would say that the police framed a guilty man. And that's kind of what they're getting at here, that the police were so intent on doing what they were doing, they're putting ideas in the witnesses' heads, words in their mouths, and they're so hovering over the entire case.
I can't tell you how hard it was for me not to respond to this innocent O.J. thing, but you and I will talk about it aside.
That makes three of us. One of the things with the investigation here is this. You can't have it both ways in this case. Either the mother is a grifter and she got her kids to make up the story in order to shake Michael Jackson down, and then the police just got the story. Or the police are overreaching and the police are leading them into this story that they wouldn't have otherwise told. It is not both ways.
Now, the idea here, though, and it's a little bit unfair to you as the public and you who weren't in the courtroom with me the other day when I went up there, when you look at this video, Howard, and I've tried to recount it the best I can, there's no, or at least very, very little evidence to everyone by my informal polling who was in that listening room, all the other journalists, of any sort of coercion in that video, any sort of forcing. So let's assume that. And aren't these jurors going to make their own judgment about what's in that video?
Sure. Well, yes, the jurors will make their own judgment, but I do disagree with something Ricky said. I think there can be both the grifter part and the overzealousness of law enforcement here. What Mr. Sanger tried to do in his examination was show that the officers took one version given by Gavin and tried to mold it into a separate version to fit their needs. That was the purpose of the cross-examination. It may not have come out that way, but that's where he was going.
But can you have the trifecta, the perfect storm, if you will, a grifter, overreaching cops, and a kid who was actually molested? Next, another investigative detective, Karen Shepard, takes the stand, and the defense points out that Michael Jackson collects a little more than porn art.
All right. Now, in the part of the house that you were in, there were books and magazines and photographs and other items that were pretty much stacked up all over the place. Is that right?
Correct.
Okay. And among the items that were stacked up there were art books. Is that correct?
Correct.
History books?
I'm sure.
Okay. Do you remember seeing any black history books, for instance?
I don't recall seeing any.
Okay. And you saw a lot of memorabilia from different kinds of films or things from the Three Stooges, for instance. Is that correct?
I don't recall seeing any.
You don't? Okay. Do you recall that there were a number of Three Stooges? When I'm saying memorabilia, a number of things that related to the Three Stooges.
I don't remember seeing anything related to the Three Stooges.
A number of things related to Shirley Temple, right?
I believe so, yes.
A number of things related to Disney and Disney productions, correct?
Correct.
None of the things that you seized were contraband, is that correct?
No.
So, in other words, they were lawful for adults to possess?
Correct.
All right. And all of what you seized was essentially commercially produced, commercially available material, is that right?
Correct.
All right. Now, when we talked about art books, there were a lot of art and photography books that you saw?
Correct.
In the various places and in the office as well, correct?
Correct.
And Mr. Jackson is a performer and an artist, is that correct?
That's correct.
So what? So what, Sean Chapman, Holly, that he has this other stuff in his house?
Well,
so what?
The so what is, I think that what they're trying to show is that Mr. Jackson is not as weird as he seems. He's got some normal stuff, too. He's got art books. He wears makeup for a reason, as came out in the testimony the other day. The mannequins are of his cousin. They're legitimate mannequins.
Howard,
so he's just trying to demonstrate. He seems like a weird guy.
We're
he's not as weird as we thought.
Evidence that goes to these charges, the adult material and the other stuff.
I disagree with Sean.
Again.
Yes. The evidence will clearly show Michael is as weird as he appears. Doesn't make him a child molester.
Okay.
What I want to say is you are correct. You can have grifters, you can have overzealous law enforcement, and you can have a child who was molested, and that is why we get back to the issue of credibility.
Yeah.
It's whether or not they believe this kid despite all the circumstances around him.
All right, when we return, we continue, and an update on what Jay Leno knows about the case. Stay with us.
The reenactments and commentary in this program may contain frank talk of a sexual nature. Viewer discretion is advised.
Welcome back. In just a moment, we're going to have a discussion about the new developments concerning whether or not this accuser ever had any dealings with Jay Leno. But first, let's go back to the teenage accuser's testimony about Jay Leno himself. Here's what the jury heard according to the courtroom transcripts.
Okay. Did Mr. Snedden ask you to testify that Jay Leno was your favorite comedian?
No.
Okay. When did the idea that Jay Leno was your favorite comedian come up in this case?
Well, Jay Leno was my favorite comedian, but I don't really understand what...
Do you remember calling Jay Leno on the telephone?
I remember calling, yeah. I remember calling his phone.
Do you remember speaking with Jay Leno on the telephone?
No, I never spoke with Jay Leno.
At any time?
No.
Did you ever try to reach Jay Leno on the telephone?
Yes.
And who did you call, if you know?
I called a phone number that I was given.
Where'd you get the phone number?
It was either Jamie Masada or Luis Palenker.
Did you dial the number?
Yes.
Was your mother with you?
No.
Was anybody in the background?
Well, when I called him, I'm pretty sure that I was in the hospital, so either it could have been my dad or maybe a nurse that would come in to do my vital signs or something.
And you dialed the number, right?
Yes.
And do you have any idea who answered the phone?
Answering machine.
And did you ever actually get Mr. Leno on the phone?
No.
So you deny you've ever spoken to him on the phone, right?
I've never spoken to Jay Leno.
And the import of that Monday testimony, Ricky Kleeman, is that news reports are coming out now that there is a tape-recorded interview with Jay Leno and a transcript that appears to contradict that very testimony.
Indeed. And Jay Leno will say, according to the transcript of his interview, that he spoke not only with the mother, he spoke with the boy. He thought it sounded coached, and he thought he was being set up. And he says words to the effect that, although he believes that Jackson is guilty, that he says they finally found their mark.
And that kind of idea, Howard, is a little scary. He believes Jackson's jury is guilty. That's got to come in because the entirety of the interview is going to come in. But finding their mark helps the defense.
You know, I have two comments. One, how do we know and how are they going to prove that Jay Leno was talking to the mother? I guess because the young man's first name was used, at least that's the inference.
Oh, you mean to authenticate the conversation?
To authenticate who had the conversation with. So I don't like that. Secondly, I'd like to know who leaked this transcript. I'd like to know how it got out into the public forum.
Well, unlike the other leaks, Sean, that apparently benefited the prosecution, this appears to be a defense beneficial leak.
Definitely, because it's hard to imagine how Gavin or anyone could have spoken with Jay Leno and not remember it.
Well, but he says he didn't remember. Then again, he says a lot of other things that didn't happen. He doesn't remember. All right, let's go around the horn real quick. We got a few seconds to go. Sean, who's ahead?
I still think the defense is ahead. The prosecution's trying very hard to rehabilitate itself, but that's a bad place to be in at this time, to have to rehabilitate yourself at the beginning of your case.
Is the prosecution, Howard?
I think Robert Blake is ahead. He showed that jurors consider credibility very, very important and considers how police conduct themselves in arriving at a verdict.
And I think the real day is Friday and what follows, because the judge is going to decide if prior bad acts, allegations by other accusers come in.
Absolutely. That's all we have for today. Tomorrow, 9 p.m., another one-hour edition, our exclusive coverage of the Michael Jackson trial right here on E!
Okay, Jay.